we're switching gears, and we're now going to be talking about the US specifically. I'm going to ask Taline to come up to introduce our next speaker. No break, because we've got people on Zoom. Interestingly, Astik's uncle and her dad were both founding members of the Armenian Bar Association. I was speaking with the uncle. I said, "Do you know what Astik's been doing on her spare time?" And he said, "I had no idea." So that's been really nice. I think you're sitting down, right, Taline? Oh, I can sit down. Yeah.
Can we do a quick sound check or?
I don't know. Am I up? Okay.
You're good. You're good.
All right.
So we're going to mute ourselves when you're talking and you mute yourself when we're talking, and we'll figure it out.
Okay.
Okay. So welcome to our second panel. And the second panel is about free speech on the Roberts Court and the Trump Court. So we're very lucky to have Professor Gregory Magarian on Zoom with us today. Professor Magarian is the Thomas and Carol Green Professor of Law at the Washington University School of Law in St. Louis. He teaches and writes about U.S. constitutional law, focusing on freedom of expression. His first book, Managed Speech, The Roberts Court's First Amendment, was published in 2017 by Oxford University Press. His research and writing also examined church and state, firearm regulation, and regulations of the media and the political press. His work has been published in the Michigan Law Review, Texas Law Review, George Washington Law Review, and other leading law journals. He has made numerous scholarly presentations and has taught and lectured at universities around the world. Professor Magarian received his BA summa cum laude from Yale and his JD magna cum laude, as well as a master's degree in public policy from the University of Michigan, where he was editor-in-chief of the Michigan Law Review. He served as law clerk for Justice John Paul Stevens of the U.S. Supreme Court and Judge Louis Oberdorfer of the U.S. District Court for the District of Columbia. He practiced law at Jenner and Block in Washington, D.C. and taught at Villanova University before joining the Washington University faculty in 2008. So it was while he was at Villanova University that he had a first speaking engagement for the Armenian Bar Association. It was over a decade ago, if I'm correct. And it was actually the speaking engagement where Hrant Dink was speaking. And it was organized by Edwin Minassian, who's being honored at this annual meeting. So everything is kind of converged to bring Professor Magarian back to us today at this annual meeting, honoring Edwin Minassian. So we're very happy to have him, very interested in his analysis of this free speech decisions on the Roberts Court and the Trump Court. The floor is yours. Oh, unmute.
Okay, there we go. Oh, we good? All right. Thank you very much. I want to thank Taline and also Armen Hovhannissian for inviting me to do this. It's an honor to be with you. I'm sorry I can't be with you in person. I was very happy and fortunate to be able to watch that last panel, and the only problem is I'm sorry I have to follow it, not just because it was so much more interesting than what I'm going to tell you, but also because I'm just going to sit here talking at you for 45 minutes on a screen, and I know that can be kind of deadly. So if you need to take a little bit of a nap in between, you know, just zone out a little bit, I will take no offense. I felt a little bit self-conscious about coming to this gathering and just sort of talking about what I do as a general matter. And then, as Taline was saying, I thought back to the panel that I was honored to speak on with Hrant Dink many years ago, and my most recent organized Armenian community event, which, like for a lot of you, was a protest around the war. And it sort of brought home to me that what I do, I think, has some relevance for our community. In my view, the First Amendment and the protection for free speech in particular has always been most important for protecting political dissidents and underdogs. And I think that describes us pretty well in a lot of circumstances. So I want to talk to you, as Taline said, about what I'm sort of provocatively calling free speech on the Roberts Court and the Trump Court. And I want to just sort of talk you through how I got to this point. Taline mentioned my book. So back 10 years ago, after the Chief Justice Roberts had been on the court for a few years, civil libertarians were starting to talk about the Roberts Court as this great court for free speech. So voices on the political left, like Burt Newborn, voices on the right, like Kenneth Starr, were together saying this court cares about free speech and protecting free speech more than any court in the past. And then kind of coming from the other side were critics, mostly from the political left, who were saying actually this court is really sort of in the tank for conservative causes and is just an activist conservative court. And I thought there was quite a bit of substance to both points of view, but I thought there was perhaps more to the story than that. So I set out to write this book that was going to just survey and assess and critique all of the free speech decisions that the Roberts Court had made. Now, I had a natural starting point, which was the Ascent to the Chief Justiceship of John Roberts. Journalists, academics often break down the Supreme Court in terms of the Chief Justice this court or the Chief Justice that court. And sometimes that makes sense and sometimes it's sort of arbitrary. In this case, it was a pretty meaningful break in the action when Chief Justice Roberts took over, partially because at the same time, roughly, Justice Alito replaced Justice O'Connor. And that personnel shift actually moved the court appreciably to the right on some important free speech issues, most notably campaign finance, which I'll say something about shortly. So to talk about First Amendment law on the Roberts Court was, I thought, a reasonable and coherent starting point. The thing that I didn't have was any kind of reasonable or coherent endpoint. So I resigned myself to the idea that the endpoint of my analysis was just going to be whenever I got the book done. And that turned out to be true, but it also turned out that right when I was getting the book done, a couple of really significant things happened. And that was first the sudden passing of Justice Scalia. And as I think you all know, the events that followed that, Justice Scalia's death, Majority Leader Mitch McConnell did not allow President Obama to replace Justice Scalia on the Supreme Court. Donald Trump then won the presidential election and was able to replace Justice Scalia, and then with remarkable good fortune for a one-term president, was also able to make two other appointments to the Supreme Court. So the end point of my book really became that the death of Justice Scalia. Because of the vacancy on the court for about a year following that, there was sort of a quiet period. When the court is split 4-4, the justices tend to be kind of risk averse and they don't take too many big cases and they can't decide anything that would be obviously a 5-4 decision. So there was a period of a year and a half where there weren't really any significant First Amendment decisions. But then the court got back into action. And so I'm drawing a distinction between what I'm calling the Roberts Court, the court basically in the period that I covered in the book, 2006 to 2017. And then the Trump Court is this new alignment that we have, where particularly with the replacement of Justice Ginsburg by Justice Barrett, the court has moved substantially further to the right. We now have a 6-justice conservative majority. And even when Chief Justice Roberts votes with the liberals on the court, the conservatives have 5 votes that can decide cases without Chief Justice Roberts. Now, what I'm calling the Trump Court is a relatively new development, and it's really just getting started. So what I want to do with you today is first sort of walk you through the analysis in my book, talking about the Roberts Court, as I'm calling it, up to about 2017. And then I want to talk a little bit about what we know so far in terms of free speech law about the Trump court. We don't know a lot, but there are a few significant cases that I think portend possibly an important shift between these two courts. So briefly, what is this shift about? We all can say pretty axiomatically that the Roberts Court has been a conservative majority court. That's been true from the beginning. But conservatism can mean a lot of different things. And I want to sort of examine two different senses of conservatism when talking about these two different periods of the Supreme Court, pre and post 2017. First kind of conservatism that I'm thinking about is what we could generally call Burkean conservatism. There are probably people in the room who are more knowledgeable about the work of Edmund Burke than I am. I'm a little bit of a dilettante on this point, but to oversimplify, Burke's conservatism basically holds that we should adhere to tradition, that we should maintain the integrity of existing institutions, that we should strive to preserve social and political stability and resist rapid change. So that's one familiar mode of conservatism. A different mode of conservatism is what I'm going to call activist conservatism. And by that, I simply mean a conservatism that is aimed at achieving and effectuating particular conservative policy goals. Now, these Burkean and activist conservatism are not necessarily mutually exclusive, but what I'm going to suggest is that the Roberts Court up to 2017 is substantially engaged in its First Amendment free speech jurisprudence in a species of Burkean conservatism, a thing that I call in the book, and that gives my book its title, Managed Speech. And I'll explain a little bit more in a moment what that means. The hypothesis, the interesting hypothesis that I want to at least begin to think about is that the Trump court may be poised to make a significant turn away from Burkean conservatism and toward a more activist conservatism, a conservatism that is aimed at achieving particular conservative political goals and policy outcomes. So that's the thrust of what I want to talk about. So first and most substantially, let me say some things about the Roberts Court from 2006 to 2017. The working hypothesis in my book about the Roberts Court, sort of descriptive hypothesis, is this idea of managed speech. And what I was trying to capture with managed speech is something that explains both the extent to which the Roberts Court really has taken free speech seriously and handed down a lot of strong free speech decisions, but also at the same time, the sense in which the Roberts Court has been notably conservative, has been conservative in a way that isn't just about protecting free speech. And it seemed to me, in examining the decisions of the court in those years, that the Roberts Court was engaged in this sort of particular variation of Burkean conservatism, that the Roberts Court was saying, yes, we want to protect free speech, but at the same time, we want to preserve social and political stability. So what I want to do is walk through some of what I think are the most significant free speech decisions of the Roberts Court and try to explain and argue about why I think those decisions fit this mold of managed speech. So in the book, I break down the court's free speech jurisprudence into three categories. The first category is just government censorship of private speech, your basic axiomatic First Amendment case. Speaker engages in speech using the speaker's own resources. Government tries to restrict the speech. Right, so that's category one. The second category I'm going to talk about, and that I talk about in the book, is what I call speech in government preserves. So any of you who have practiced or studied First Amendment law very much will know that there are a lot of First Amendment cases, a surprising number, I think, for people who don't know a lot about First Amendment law, that deal with speech either on government property or speech that uses government money, perhaps government grants or subsidies, speech by people who are subject to special government authorities, students, prisoners, public employees. So all of these types of First Amendment cases I group under this category of speech in government preserves. And then the third category is one that in other periods of time, you might not have to break out as a separate thing, but for the Roberts Court, you have to absolutely do, and that is speech related to elections. And the reason that that category of speech on the Roberts Court requires its own category, its own sort of box, is that the Roberts Court's premier preoccupation in free speech law has been electoral speech and particularly campaign finance. There is no subject, nothing even close, as to which the Roberts Court decided more free speech cases than questions of campaign finance regulation. So I want to talk about a couple of cases in each of those three categories. Again, talking now about the Roberts Court in those years of 2006 to 2017. And what I want to illustrate is that even whether the government wins or whether the challenger, the speaker, wins, there's a consistent theme of what I'm calling managed speech, of this desire to do First Amendment law, make First Amendment law in a way that preserves political and social stability while at the same time allowing a substantial sort of or substantial amount of free speech. So let me start with a couple of cases in that private speech category, basic, straightforward First Amendment cases. The first one I want to talk about is, for my money, maybe one of the very most important First Amendment decisions of the past 20 years, a case called Holder versus Humanitarian Law Project. So in this case, some US-based advocacy groups wanted to engage in a sort of dialogue with a couple of foreign groups that had been designated by the State Department as foreign terrorist groups, the Tamil Tigers in Sri Lanka and the Kurdistan Workers' Party. And what these US-based groups were saying is, we want to talk to these foreign terrorist groups and try to counsel them and advise them about how they can resolve their political aims in a peaceful rather than violent way. We want to teach these terrorist groups, help teach these terrorist groups how to work and play well with others rather than keep blowing things up. There's a law, federal law, that prohibits US persons or organizations from giving material aid to any group that's on that State Department foreign terrorist list. And so these US-based groups in the Holder versus Humanitarian Law Project case were concerned that their activities would violate that law, and so they sought a declaratory judgment. And this case found its way to the Supreme Court on the First Amendment issue. Would it violate the First Amendment for the US government to prohibit these US advocacy sort of do-gooder groups from engaging in the kind of discourse with these foreign terrorist groups that they wanted to engage in? The really remarkable thing about this case and the Supreme Court's decision, Chief Justice Roberts writes the majority opinion, and he acknowledges rather easily that this case has to be reviewed under strict scrutiny. It's a content-based regulation of speech. So in order for the government to be able to stop these groups from doing what they want to do, the government has to satisfy the most rigorous form of First Amendment review. And with a couple of caveats, no prior Supreme Court decision that remains valid precedent, in no prior Supreme Court case that's still valid law, had the government ever prevailed on strict scrutiny. It's vanishingly unlikely for the government to win under that standard of review. And yet, in Holder versus Humanitarian Law Project, the government wins. Chief Justice Roberts' opinion is dripping with contempt for these US advocacy groups that want to engage with the foreign terrorist groups. Chief Justice Roberts all but calls these organizations dupes. There's no question about the innocence of their motives. No one questions that, but Chief Justice Roberts basically says any kind of assistance that you render to these foreign terrorist groups is going to come out the other end as violence. These political advocates have no business making the decision or the determination that their engagement with these groups can be constructive. The State Department has made an authoritative determination that engaging with these foreign terrorist groups is destructive and impermissible, and we, the Supreme Court, are going to validate the State Department's, the government's decision. To me, this is a cornerstone case for the managed speech thesis that I'm seeking to impose on the Roberts Court's free speech decisions. The court rejects a First Amendment claim under the most rigorous form of constitutional review based on the idea that we are not going to let disruptive, ragtag, dissident type speakers upend our establish political and social order. These, in the courts telling these claimants in the Holder case, are not responsible, trustworthy speakers. They are potentially destructive, and we are not going to allow the First Amendment to validate their claims. All right, let me talk about another case a few years earlier in which the court sustains a First Amendment challenge to a government regulation of private speech. This is a case called United States versus Stevens. In this case, the federal government had passed a law prohibiting certain depictions of cruelty and violence toward animals. The law was actually inspired by and directed at a particular sexual fetish about which the less said, the better. But the legally important matter is that this federal law as written applied more broadly than that. It applied to a lot of different depictions of animal cruelty. And so the person who challenges this is a producer of dogfighting videos. And he says, this federal law bans what I'm doing and it violates the First Amendment. Now, the government in this case made a bold play. The government, in litigating United States versus Stevens in the Supreme Court, said, Supreme Court, what we want you to do is announce a new category of unprotected speech. Part of the structure of First Amendment law involves categorical exclusions from First Amendment protection: obscenity, defamation up to a certain point, incitement of lawless action, yelling fire in a crowded movie theater. These are categorical exclusions, and the government in this case says to the court, make another categorical exclusion for certain extreme depictions of violence. And the court emphatically rejects the government's entreaty and holds in favor of the producer of the dogfight videos. Now, here's what's really interesting to me about United States versus Stevens. You might look at this case and say, okay, the First Amendment claimant wins. This is certainly not a sort of respectable, responsible institutional speaker. But what's important about Stevens is what the court says in this case. Chief Justice Roberts again writes the majority opinion, and he says the reason we're not going to declare a new category of unprotected speech is because we believe the right way to make First Amendment law, and in particular to figure out categorical exclusions to First Amendment protection, is tradition. Tradition should be the guiding force in any difficult question of First Amendment law. We should look to whether in the past, over time, our law has allowed regulation of the sort of speech in question or has protected the sort of speech in question. In this case, we refuse to create a new category of unprotected speech because traditionally no such category has existed. This is the basic language of Burkean conservatism. Make decisions based on tradition, resist rapid change. So here, even in a case where the court is handing perhaps a somewhat shady First Amendment claimant a major victory, it's doing so on managed speech terms, on saying we are going to use tradition as the way that we define and develop First Amendment law. All right. Let me now talk about a couple of cases in that second category that I described, speech in government preserves. So again, this is the sort of broad range of First Amendment cases involving government property, government money, and speech by people subject to government institutions. The first case I want to talk about falls into that last government institutions box. It's a case called Garcetti versus Tobias. Anybody who practices employment law is probably familiar with this case. This is a case about a government employee who is seeking First Amendment protection for his speech. Particular government employee here is one of us, not an Armenian, but a lawyer. An assistant district attorney in Los Angeles. So this assistant DA, Tobias, comes to believe through some investigation and information that he finds that his office is committing misconduct in one of the cases it's prosecuting. And so Tobias writes a memo to his superiors and meets with his superiors saying, hey, I think we are doing something wrong in this case, and I think we should stop doing what we're doing. And in response to Tobias' efforts, he is disciplined and demoted. So he brings a claim that the adverse actions against him based on his speech violate the First Amendment. He's invoking a long-standing doctrine in First Amendment law called the Pickering Doctrine that gives public employees in certain instances the benefits of a First Amendment balancing test. So in a lot of instances, government employers, like private employers, have good reasons to limit the speech of their employees. But the Pickering Doctrine says when a government employee is speaking as a citizen about a matter of public concern, we will give that government employee the benefit of a balancing test if the employer tries to restrict his speech. And the balance sort of takes into account the employee's speech interest and the government's interest in running its operations efficiently and effectively. Justice Kennedy writes the majority opinion in Garcetti versus Tobias, and he doesn't even give Tobias the benefit of the balancing test. Kennedy says this case gets knocked out at the threshold level. It doesn't, what Tobias did isn't entitled to any possibility of First Amendment protection. And the reason Justice Kennedy gives is what's novel about the case. He says Tobias said what he said and wrote what he wrote in the course of his employment, and therefore he doesn't get any First Amendment protection. Kennedy all but says that what Tobias did was work product that his employer, the district attorney's office, found inadequate or insufficient. If we take a step back here, there's a lot of irony in this case. Tobias looks a lot like a classic whistleblower, except he's not doing what whistleblowers axiomatically do, which is going public, going to the press. Instead, he's trying to resolve what he sees as a problem in his office internally. He goes to his superiors and says, hey, I think we're doing something wrong. You would think from the standpoint of government employers, we would want to encourage that kind of action rather than going public. If Tobias had gone public, it would have been hard to argue that he wasn't speaking as a citizen on a matter of public concern, the threshold that Pickering establishes for a government employee to get this balancing test. Instead, Tobias does what he does internally, and the court rejects, denies him any kind of First Amendment protection at all. This is a managed speech case in the simplest sense. The court says we are going to let government entities, government institutions decide how they're going to be run. And again, we are not going to permit a disruptive dissident speaker to upend that steady, organized, responsible status quo. All right. Contrast Garcetti versus Tobias with a different kind of government preserved case, a case called McCullen versus Coakley. This is a government preserved case under the public forum doctrine, the principle that establishes First Amendment rules for speech that takes place on government land. And this is the simplest kind of public forum case, a case about people engaged in expressive activity on public streets and sidewalks. McCullen versus Coakley is an abortion protest case. So the state of Massachusetts, like a lot of states, established what's called a fixed buffer zone rule to protect clinics and facilities that provide abortion services. A fixed buffer zone says people who are protesting, arguing against abortion and abortion rights have to stay a certain distance from the grounds of the clinic. And the state justifies this rule, as most of these rules are justified, by saying we just need this rule so that people can have access to these facilities and get necessary medical services. And this issue has a history in the Supreme Court. There had been a decision some years back that had validated this kind of fixed buffer zone rule over bitter dissents by the court's most conservative members. All right, so in McCullen versus Coakley, in the Roberts Court, a group of anti-abortion activists challenges Massachusetts fixed buffer zone rule. And the outcome in this case is really interesting, and the breakdown on the court is really interesting. It's unanimous, the abortion activists unanimously win, but there's a sharp divide on the court in terms of the reasoning. Chief Justice Roberts writes the majority opinion, joined by, at that time, the court's 4 liberal members. The 4 other conservatives write a very angry, or Justice Scalia on behalf of 4 other conservatives, writes a very angry concurrence in the judgment. And here's the legal breakdown. What the conservatives, what Scalia wanted the court to do was overrule the earlier precedents that had allowed this kind of fixed buffer zone and say, this is a content-based regulation of speech. It's targeting anti-abortion speech for unfavorable treatment, and therefore the state shouldn't be able to do this at all. And Chief Justice Roberts rejected that approach. Instead, what he did was he said, all right, we'll accept that this is a content neutral regulation of speech, a regulation that's aimed at protecting access to clinics and not at suppressing a particular message, in this case, the message of anti-abortion activists. The reason that we're going to strike down this law ultimately is because it's not narrowly tailored enough. It's too broadly framed to establish accomplish the state's interest while not restricting more speech than necessary. So it's a narrower ground for striking down the law. That's what Justice Scalia was angry about. He wanted the court to rule on the broader ground. Chief Justice Roberts essentially very strategically co-opted the court's liberals and said, look, I'll write a narrow decision if you guys join me and don't write any concurrences. And so that's what happened. All right, here's what fascinates me about this case. Again, this might look like a case that kind of defies the managed speech norm, because here you've got some, street activists. Certainly, whatever you might think of their politics, they fall into that category of ragtag dissident, disruptive speakers. But in the opinion, Chief Justice Roberts characterizes these anti-abortion claimants in a very particular way. He repeatedly says, these are not protesters. He emphatically says it's wrong to attach the protester label to them. These are counselors. And this is the story that these anti-abortion activists were telling about their own activities. What we do at abortion clinics is we counsel women not to get abortions and to seek other approaches to their pregnancies. And Chief Justice Roberts loudly validates that characterization. That's interesting to me because protesters are a problem under the managed speech paradigm. If you look at the Roberts Court years, you don't see any First Amendment decisions that really validate the First Amendment rights of protesters in the way that we would think of that term to include Black Lives Matter protesters, Tea Party protesters, Occupy protesters, kind of people who take to the streets and make noise and make some trouble. Chief Justice Roberts gives certain species of what I would call protesters in McCullen versus Coakley a First Amendment victory, but only on the understanding that they aren't really protesters, that they're much more respectable, much less disruptive than grubby protesters. They are instead respectable, trustworthy counselors. And that rhetoric is what brings McCullen versus Coakley into the managed speech fold. All right, the third and final big category of free speech decisions that I want to talk about are broadly defined electoral speech cases, and really for the most part, we're talking about campaign finance cases. There are a couple of other interesting electoral speech cases in the Roberts Court years, but most of the big decisions, I said earlier, most of the biggest group of free speech decisions at all in the Roberts Court are cases about campaign finance. Now, I have to break my form in talking about this category. I can't give you a case where the government wins and a case where the speakers win, because in campaign finance cases on the Roberts Court, the speakers almost always win. There's a couple of very marginal exceptions, but overwhelmingly, the court in this area strikes down laws and validates the free speech claims of people who want to spend and use money in elections in various ways. So I'll talk about two cases. One of them is the one you've heard of. If you have heard of no other Roberts Court free speech decision, you know about Citizens United versus FEC, case that famously strikes down a longstanding federal prohibition on corporations and labor unions making expenditures to support or oppose candidates in federal elections. Citizens United has the effect of also killing a whole bunch of parallel state laws. A lot has been said about Citizens United. I want to zero in on one particular strain of the court's reasoning and rhetoric. The Citizens United opinion is interesting. Justice Stevens says in dissent, this majority opinion is basically a bunch of strung together quotations from dissents that the justices who are now in the majority had to write back when they weren't in the majority. And he's not really wrong. Justice Kennedy writes the majority opinion in Citizens United, and he does quote an awful lot from prior dissents written by particularly him and Justice Scalia. And I want to zero in on one of the particular Scalia lines that Justice Kennedy brings into Citizens United. In an earlier case, Justice Scalia says, it's a really bad thing to exclude corporations from being able to participate in election debates and spend money in elections, because corporations represent the most important forces in the economy. They are the dominant economic actors in our society, and they should be able to influence elections. And I think that's very striking. People who defend Citizens United usually defend it as in sort of negative rights terms. This is a decision that prevents the government from engaging in a sort of repressive, tyrannical regulation. But Justice Scalia's argument that Justice Kennedy brings into the Citizens United opinion actually provides an affirmative justification for the court's decision in Citizens United. We don't want to just stop the government from repressing speech. We think it's especially important that this category of speakers, business corporations, who are really the entities that benefit from the Citizens United decision, we think it's affirmatively important that those entities get to influence elections because they're economically dominant, because they are the most important actors in our economy. And so this is, again, sort of an axiomatic managed speech idea. We have a status quo. The status quo is preserved and defined in some ways by economic power and the people and entities who hold economic power. And Citizens United is saying those entities, because of their economic power, should be able to exert substantial influence over our democratic processes. All right, one more Roberts Court case, one more campaign finance case that in some ways goes even further than Citizens United in a managed speech direction. And this is a case with the mouthful title, Arizona Free Enterprise Club's Freedom PAC versus Bennett. I'll just call it Arizona Free Enterprise to spare further pain. This is a state campaign finance regulation case. And here's what happened. Arizona, like a lot of states, has a voluntary public financing law for certain state elections. If you're running for certain state offices, state legislature, you can choose to finance your campaign using public funds. If you do that, you agree not to take private money. And so far, that basic structure has not gotten struck down by the Supreme Court. But Arizona added a twist. Arizona said, if you accept public financing, and if your opponent doesn't, and if your opponent raises money either through their own fortune or through private fundraising over a certain level, we will give you more public money to sort of match up to a certain threshold the private money that your opponent is getting. Now, what's fascinating about this case, the Supreme Court, spoiler alert, strikes down the Arizona law. Justice Kagan in dissent says, how can you strike down this law if the whole basis for First Amendment jurisprudence is that we should have as much speech as possible? This is a case where what Arizona is doing enhances electoral debate, makes certain, or at least helps to make more likely, that both candidates of the two major parties, at least, will be able to get their messages out and be heard. And that's got to be a good thing, right? And the court, in another majority opinion by the Chief Justice himself, says, no, it's not a good thing. And the reason it's not a good thing, ultimately, the answer that Chief Justice Roberts has for Justice Kagan's objection is the government here is diminishing the influence of private money. The government, by providing more public money for one candidate, is diluting the effect of the private money that the other candidate is spending, and that violates the First Amendment. Think about it for a minute. That is fascinating. If you have a lot of resources, you don't just have the right to spend those resources or contribute those resources in elections as a matter of First Amendment principle. Now the court is telling us you have a right to spend or contribute that money and not have the government dilute the impact of your money. You have the right not just to speak, but you have the right to be heard. And that's a principle that the court has rejected in most other settings in First Amendment law, but in campaign finance, in Arizona Free Enterprise, the court says that you have that right. All right, take a breath. That's what I want to tell you about the Roberts Court up to 2017, about this idea of managed speech that I think all of these important cases fall into. Now I want to shift gears and talk about the court post-2017. And as I said, we don't have a lot of decisions yet. We don't have the same dossier on the post-2017 court that we have on the prior decade, but we do have some important cases. And I want to talk about just a few of the cases decided, free speech cases decided by what I'm calling the Trump court. And use these cases to illustrate what may be some trends, or maybe not, but at least some hypotheses that I have about where the court is going and may go over the next years. First, a case called National Institute of Family and Life Advocates versus Bacara. This is another case involving the underlying issue of abortion. In this case, California had imposed some regulations on what are called crisis pregnancy centers. Crisis pregnancy centers, as understood in this case, are clinics run by groups that oppose abortion, that provide alternative services to women who might otherwise get abortions. And the twist is that the crisis pregnancy centers aren't always forthright about where they're coming from and what their political position is and why they offer the services they do. They try to sort of steer women to accepting their services. So California, with that issue in mind, imposed a couple of regulations. Some crisis pregnancy centers are licensed by the state. And for those licensed CPCs, California said, you've got to disclose to your patients the availability of alternative publicly financed pregnancy services, including abortion and contraception. You've got to tell your patients that those services are available. For unlicensed crisis pregnancy centers, the regulation simply said, you've got to inform patients of your unlicensed status. The logic here of the regulation is that the government usually has more latitude to impose requirements on people or entities that the government is licensing. That cuts across a lot of different kinds of licensure. The crisis pregnancy centers challenge this California regulation, and the Supreme Court, in an opinion by Justice Thomas, strikes down the California regulation. The court says this is a content-based regulation of speech. You're compelling the crisis pregnancy centers to say something that they don't want to say, and you are restricting their speech and their message by imposing this requirement on them. It's hard not to contrast this case, National Institute of Family Life Advocates, NIFLA, it gets called in writing, against McCullen versus Coakley, the other abortion speech case that I talked about. And a couple of things. McCullen versus Coakley, as I described, there's this interesting sort of ideologically scrambled coalition in the outcome of the case. In NIFLA, that's not the situation. This is a straight liberal versus conservative split. The conservatives vote in the majority, the court's liberals vote in dissent. And it's also striking how the court bends over backwards to validate and promote the speech of a particular kind of anti-abortion advocate. Again, maybe what we could, if we were being critical, say, at least in some cases, are somewhat shady operations, these crisis pregnancy centers that are being obscure or opaque about what their motives and what their activities really are. The court says that's okay. We're perfectly comfortable allowing, prohibiting the state from regulating those entities by virtue of the First Amendment. The second case I want to talk about is one you may have heard of, and you may not know it's a First Amendment case, but it is Rucho versus Common Cause. This was the big partisan gerrymandering case. Now, partisan gerrymandering has a tortured history in the Supreme Court. Partisan gerrymanders have come up to the Supreme Court a few times over the past few decades, and the court had always been hopelessly kind of scrambled in its how it thought it could deal with partisan gerrymanders. And Rucho is the final sort of Ragnarok of partisan gerrymanders on the Supreme Court. But the thing that makes Rucho fit into my conversation is that the theory on which the challengers in this case were trying to attack partisan gerrymanders was a First Amendment theory. They tried some other things in other earlier cases, and the court had rejected them. But Justice Kennedy, in a concurrence a couple of decades ago, had suggested a First Amendment angle. And so that's the angle that the challengers in Rucho tried to use against partisan gerrymanders. They said, all right, partisan gerrymanders violate the expressive associational rights of whichever party is being disadvantaged by the gerrymander. If Democrats control the legislature and they're imposing a partisan gerrymander and undercutting the political power of Republicans, one thing that's doing is making Republicans unable to effectively engage in expressive association, a doctrine that has long roots. Expressive association doctrine generally has long roots in First Amendment law. And so the challengers in Rucho are saying that's the basis, Supreme Court, on which you should reject or limit partisan gerrymanders. It's a First Amendment problem. And I think the challengers had good reason to think that that might be a successful theory, given how far the court had stretched the First Amendment in a lot of areas in the Roberts Court years, particularly in with regard to electoral speech. But the court, as we probably know, rejects that argument and declares partisan gerrymanders to present a non-justiciable political question. We, the Supreme Court, are incapable of deciding constitutional challenges to partisan gerrymanders because, says Chief Justice Roberts in his majority opinion, partisan gerrymanders do not allow for any judicially manageable or cognizable standard. Now, this is striking, given how far the court had stretched and how creatively the court over the past decade plus had been developing First Amendment law. The court, in no other context, had suggested that a First Amendment challenge presented a non-justiciable political question. But when it came to partisan gerrymanders, the court said, we just don't even know how to make First Amendment law here. That was, to put it mildly, an outlier decision. Last case I want to say anything about, and this one's kind of a ringer because it's not actually a First Amendment case at all, but I think it's a really important free speech case. A case from just earlier this year called Cedar Point Nursery versus Hasid. This is actually a takings clause case. And here's the deal. It's another California case. And in this case, California has a law dealing with union organizing campaigns for farm workers. And what the law said was, if a union is trying to organize farm workers, the farm owners have to give the union representatives a certain kind or degree of access to the farm so that the union representatives can talk to the workers who they're trying to unionize. Farm owners challenge this as a per se taking, as tantamount to the government seizing their land, albeit in a more limited way. A radical, very creative takings clause theory, and the Supreme Court in Cedar Point Nursery buys it and says, yeah, that law imposes a compensable per se taking on the farm owners. Now, there's some background here that does have to do with First Amendment cases. The court in another case that you may know about called Janus versus AFSCME had fulfilled a line of decisions that began in the earlier Roberts Court years. Janus is a Trump court case that really limited the ability of public employee unions to collect any kind of fees from non-members. The basic story is the Roberts Court before Trump, and certainly the Trump court, had demonstrated some really powerful hostility toward unions. But Cedar Point Nursery is, to my mind, another order of magnitude, saying that a union organizing campaign, communication in a union organizing campaign is a seizure of property. So not only are we going to not recognize the First Amendment free speech interests here, we're going to say that the free speech that the unions are trying to engage in violates the rights of property owners, and that's the important constitutional principle here. All right, what do we make of these decisions? What do I make of these decisions since I'm the one talking? Just a few things. There's a lot we don't know. We haven't had too many Trump court decisions yet. But here are a few observations. If you'll notice, and this was not planned, I noticed this after I selected the cases that I thought were important and representative. All of the Roberts Court 2006 to 2017 cases that I talked about, majority opinions were written either by Chief Justice Roberts or by Justice Kennedy, who we would broadly, generically categorize as on the center right of the court. In addition, at least a couple of those important cases, US versus Stevens and McCullen versus Coakley, involved ideologically diverse coalitions, ideological scrambling of the court's membership in terms of who was in the majority and who was in the dissent or concurrence. In all of the important Trump court cases that I've talked about, the cases are all straight left-right splits, no ideological scrambling at all. And two of those cases are written by Justice Thomas. The other one is written by the Chief Justice. Justice Thomas didn't play a very important role in First Amendment law in the pre-2017 years. Justice Thomas is an unabashed activist conservative. he might not quite put it that way, but I think he would probably cop to the basic notion. He has ideas about how the law should work and what the world should look like. And his sense of making constitutional law is have the law serve those purposes. The law should direct the world the way that I think it should work. That's activist conservatism. It's not Burkean conservatism. Justice Thomas doesn't care about preserving the status quo. He sometimes cares a lot about returning to the status quo circa 1800. So the fact that he has that much more influence in the Trump court years is itself a sort of striking distinction. The new justices, by the way, haven't written any really important free speech cases, but they're just getting started, Gorsuch and Kavanaugh and Barrett. A couple other observations. In general, the Trump court free speech decisions don't really care, don't manifest much concern about social and political stability. All of the Roberts Court cases that I talked about, the pre-2017 cases, in one way or another, are concerned with show an attention to preserving political and social stability, whether the speaker's winning or the government's winning. Nothing in the Trump court cases manifests that kind of concern. Conversely, as I said at the beginning, a fair number of critics of the Roberts Court have said all along that the Roberts Court is an activist conservative court. And my thesis kind of pushes against that a little bit. And I may be wrong, I may be partially right, but I think there's at least a colorable argument for the reasons that I suggested, that those Roberts Court pre-2017 free speech decisions aren't necessarily activist in their conservatism. They are instead Burkean. They are instead trying to, again, preserve the political and social status quo. The Trump court cases seem much more unabashedly activist. Anti-abortion advocacy, the electoral prospects of Republicans who generally benefit disproportionately from partisan gerrymanders, weakening unions. These are conservative political social goals. And these cases in the Trump court directly and aggressively advance those goals. So I don't know what the next years hold, none of us does, but I think it's at least worth keeping in mind the hypothesis that what we may be seeing on this new court with its stronger conservative majority is, in free speech cases, a new kind of conservatism, activist conservatism, rather than Burkean conservatism. And that could be really important across a whole range of First Amendment issues that will have impacts in all kinds of areas of social life. So thank you very much for listening to this whole spiel. And now I think we're going to do some Q&A, and I'd love to answer any questions you have about anything.
Thank you so much, Professor Magarian. That was very interesting. We can feel the passion you have for these cases. You can really, and this area of the law. We have some questions in the chat. I'm wondering if you can you see them on your end?
Hang on, I'm really bad at Zoom. So, okay, here we go.
There's one, maybe we can put it up. Can you put it up on?
Yeah, I'm okay. So I'm seeing these. Let's see. So do you want me to just take them in order if I can?
Yeah, let's take the one from Mr. Krikorian. So he's, you can read it. Can everybody see it here? Yeah.
Okay. So this is foreign influence on elections. This is a really interesting question. And Taline and I had she had actually thrown some questions at me for potential discussion questions, and this was something that she raised. So this is really interesting. And again, I'm going to sort of talk about it within the frame of conservatism, colloquially understood. Citizens United demonstrated the strong strain of conservatism that says, again, money should be free in elections. But there's also a strong strain within conservatism that we might call nativist conservatism that says we really want to avoid foreign influence on domestic affairs, whether benign or malign. And you can have a more sort of refined version of that impulse that isn't necessarily nativist, that says sort of what you're saying. Okay, look, elections are really important, and foreign actors are exerting malign influence on elections in some pretty demonstrable ways. And what is the law going to say about that? And there is some language in Citizens United that suggests that it might be difficult to maintain prohibitions on foreign nationals spending and contributing to domestic elections, which those prohibitions have existed for a long time. My instinct is that the court, pre-2017 and post-2017, would not be inclined to widen the ability of foreign nationals to influence domestic elections, and further, that if Congress were to take action to try to, I'm getting a doubling here, sorry. If Congress were to try to put more restrictions in place, I think the court would probably accept that, but it is a little bit tricky. And one reason it's tricky, Taline in her framing of this pointed to an opinion by Justice Kavanaugh, where he sort of made a broad declaration that foreign nationals outside US territory do not have any constitutional rights. And an FEC commissioner sort of ran with that and speculated in an op-ed that, hey, maybe this is a basis on which we can shut down these sort of foreign, social media spam bot, influences on elections. The problem is the caveat in that sweeping statement by Justice Kavanaugh: foreign nationals not in US territory. When you're talking about electronic communications, you can sort of, as I'm sure most of you know, source and originate those communications wherever you want to. So it might be the case that foreign governments that wanted to influence, or foreign interests that want to influence US elections, simply find US partners to originate the communications and allow them to propagate their messages. And that might be a more difficult problem to regulate without running afoul of the First Amendment. So there are a lot of moving parts here. I don't have any kind of a categorical answer, but I think we've got these sort of competing influences. Let money be free in elections. Don't let foreigners influence domestic affairs. And I think there's a lot of play in the joints between those two competing influences that, depending on how foreign interests proceed, and of course, depending on what Congress can actually muster the political will to regulate, if anything, that's going to determine whether we get any effective limitation on these sort of attacks on our electoral process.
We have just two more questions quickly. Do we have time, Lucy?
Okay, I'm sorry. Let me, I got to get back into the chat here.
Do you want to unmute?
Oh, so, okay, upcoming First Amendment cases.
Yes, Claire's and Thelma's questions, yeah.
So there's not a lot yet in the upcoming term, big First Amendment cases, but there's one that might seem a little bit minor or obscure that actually has the potential to be pretty major. And this is a case about neon signs. So sign regulations are actually a kind of important First Amendment battleground. Municipalities put all kinds of regulations on what kinds of signs you can have, that they can't be too big or they can't be in certain places. And in a case a few years ago, the Supreme Court reviewed a really ham-handed, overly broad sign regulation. But in the case written by Justice Thomas, the majority opinion, it makes this sweeping statement that, any kind of sign regulation that has to do with what the sign says is a impermissible content-based regulation of speech, or at least a content-based regulation that's subject to strict scrutiny and thus very likely to get struck down. And Justices Kagan and Breyer wrote concurrences sort of saying, man, do you really understand the implications of what you're saying? Like, you can't have any kind of regulation that says you can have a certain kind of commercial sign in this area, but you can't zone it for this area. So the case that's coming up this year is about a sign regulation a city has that says you can't have a neon sign unless it is adjacent to, essentially, unless it's located at the business that it's advertising. And this is getting challenged as a content-based speech regulation. This is the kind of First Amendment case that, in 2000 would never have gotten to the Supreme Court. There would have been no way that the Supreme Court would strike down a regulation like that. Now, it's pretty clear that the court took this case to strike down the regulation. And what's important about it is that one element of the analysis is that this is a regulation of commercial speech. And some of you may know commercial speech has long been a contested and somewhat confused area of First Amendment doctrine. The Supreme Court has said that the government has greater latitude to regulate speech that does nothing more than propose a commercial transaction than it has to regulate other kinds of speech. But some justices, notably Justice Thomas, have been beating the drum against that distinction for a long time. There may now be a majority on the Supreme Court to strike down the commercial speech categorical distinction altogether, and this may be the case in which that happens. That's why it's a potentially very important case. And all right, let me just get back in. Cancel culture. What do we have? About 30 seconds on cancel culture. Okay, when you asked me about cancel culture, I just have to tell you, you are pushing some very significant buttons of mine. I strongly contest the notion that what people call and raise alarms about when they say cancel culture is really what the alarmists say it is. I think much of cancel culture is what I would just call a culture of greater accountability, and in particular, a culture of greater accountability where people and types of people who haven't always had much opportunity to participate fully in public discourse now have that opportunity. So you have more people of color calling out racism. You have more women calling out misogyny and calling out callous treatment of women in various things that people say. To the extent those things are sometimes, result in extreme measures, I think all good and positive social phenomena have excesses, and that may be what some people mean when they talk about cancel culture. The other thing about cancel culture, I haven't really noticed anybody getting canceled. People say J.K. Rowling got canceled. People say Dave Chappelle got canceled. Last time I looked, these people have a whole lot of money and massive audiences. And if that's cancellation, sign me up. So I got feelings about cancel culture and thoughts, and I'll just stop it there. It's an interesting topic.
Do we have one? Can we have one more question? There's questions in the room. Oh my God. Can you?
Oh, now I'll get everybody angry at me. So
like through cancel culture, aren't we just canceling okay culture, where every misogyny, racism, sex, all that is no longer okay, and isn't that the answer ultimately?
Yeah, I mean, I think I would strongly agree with that, and because you're kind of in the same space where I am, I'll try to step back and annoy you maybe by being try to be a little bit circumspect about it, if I'm even capable of that. I think one of the really fascinating things for me about studying free speech, First Amendment law, but also the broader phenomenon of free speech, is that we don't just have the same conversation all the time, taking place under the same norms and the same rules. Social norms change, and the law changes to some extent, but what's really important is that social norms change. Racist speech, blatantly racist speech, let's not be subtle here. Let's talk about, really blatantly racist speech is protected by the First Amendment, but it faces strong societal disapprobation and has for a long time. And now that disapprobation is extending to what might be more nuanced forms of racist speech, to continue this example. And I think this is what you're talking about with okay culture. And what that is a shift in social norms. And one way of viewing that shift in social norms is through the prism of free speech. And so as norms shift, people whose speech is being pushed toward the margins or out of the space of respectability inevitably say, my speech is being muted. If the government's doing it, I'm being censored. If social forces are doing it, I'm being canceled. And I think that's kind of normal. And I think that's always happened. And whatever we think about the good or bad of the social norms in question, it's an interesting phenomenon to observe. And I think something we have to acknowledge, that free speech doesn't always, the conversation changes. And the fact that the conversation changes, and the fact that the way we talk to each other changes, and the way that what we think of as respectable and not respectable changes, that's consistent with an ethos of free speech. That's not a violation of it. That's what happens when you talk to each other for a while and you reach some kind of consensus about what ideas are worth examining further and what ideas aren't. And I think that's that big phenomenon is sort of at the root of what we're talking about when we talk about cancel culture.
Okay, we have one more question. I think this is the last one.
What does history say about how the other branches of government, executive or Congress, respond to an active support?
I didn't quite, Taline, I didn't quite get that.
What does history say about how the other branches of government respond to an activist court?
Oh, that is a great question. And I guess one thing I have to say as a baseline, I think this is probably part of, within your premise, it sort of depends on who's in charge of the government and who's in charge of the Supreme Court. And I think, based on Tuesday's election results, if we want to be of the moment about it, we may be looking at a period of time where if the electoral currents run toward Republicans, we'll have a fair amount of harmony between an activist court and a government that has similar policy goals to what the activist court is concerned about. And in a situation like that, we're going to see great harmony. Now, what's fascinating about it is that because of gerrymandering and a lot of other things, the government, particularly the Senate, may not very accurately represent public sentiment. And so we might have a broader public government split overall than we've seen. But in terms of, when you've got an oppositional relationship between the court and the government tends to push the envelope. And sometimes, interestingly, it works. The Supreme Court has final authority, as we know, to decide what the Constitution means. But look what happened during the New Deal period. Roosevelt comes in, starts passing all of these New Deal programs, and initially up until 1936, the Supreme Court is very activist in striking down what the government is doing. And then in 1937, everything changes. And historians have explained this in different ways, but I think in the simplest terms, one way or another, the court looks at what's going on in the world, what the government is doing, and says, okay, we can, authoritatively decide constitutional law all day, but ultimately we can't dictate the way the world works. It's just not going to end well for us. And maybe we even learn something if we pay attention to what everybody else is doing differently from what we're doing. There have been other somewhat less dramatic situations. There's a great book by a constitutional scholar, Barry Friedman, who talks about constitutional dialogue. And he points out, for example, that, the court decides Roe versus Wade, and then the anti-abortion movement gains steam, and the court comes back 15 years later in Planned Parenthood versus Casey and sort of modifies Roe. And in that instance is candid about it, says, look, we're trying to strike a balance on this very difficult issue that sort of validates the competing concerns as much as they can be, or reconciles them as much as they can be reconciled. So the court historically has sometimes listened to the public when the public has said, we don't like what you're doing. The court has sometimes listened to other branches of government when they've said, we don't like what you're doing. Our political context now, as everybody knows, is very distinctive. I mean, every moment is its own moment, but our moment is one of great polarization and great digging in of heels, and of, I think, very conscious use of institutions to try to establish goals without regard to sort of norms of comity and cooperation. So I don't know how much I see the Supreme Court responding if the public or if other branches of the government say, you're going too far. But we've got some new justices and we don't know what their temperaments are. So there's a lot that's terrifying, but if you do what I do, terrifying is interesting. And so a lot of interesting stuff to pay attention to on that score.
Thank you so much, Professor Magarian.
Thank you all. I really appreciate your listening to all this, and thank you again for letting me do this.
So I think that wraps up our second panel. So I'll hand it over to Lucy. Bye.
Thank you, Greg. Thank you, Taline, for this wonderful presentation. This is the end of the fun stuff. We are now going to transition into the business meeting of the Bar Association. We're going to give folks just a couple minutes to take a quick break. I'm going to ask Nadik to show the slides on our sponsors. We're very proud of everyone who has supported us in this very fine way. So please take a couple minutes and we will be right back.
Your Honor.
Nadig, I think we're ready to get started.